Namaste, this is Advocate Surya Kundeti, and today in our class Civil Procedure Code 1908, the topic is second appeals. In our earlier class, we have discussed about the first appeals, which we do it in the higher courts. And before we start this class, as usual, it is my duty to mention that I'm doing this online classes as a charity to an organization by name ABC Trust. And this trust is involved in improving the nutritional benefits of school-going children and also for their education. So, if you are happy with my class, may I request you to please donate a small contributory donation of 15 rupees for this class, which will be utilized for nutritional benefits of school-going children and their education as well. Also, in addition, please subscribe to my channel, because the more the number of subscriptions I keep on getting every day or every week, the subscriptions are directly proportional to my encouragement. So the more the subscriptions, I'll be making more and more classes in the future as well for all the subjects. End of this class, we are going to show you the QR code that is related to the ABC Trust. You can scan the QR code and you can make the donations. Also, you can use the UPI number 994939 8998, which is going to be shown at the end of the class as well. And now, let's get into our class. So, second appeals. In general, second appeals is related to section 100 to 103, 107 and 108, and order 42 deal with second appeals. Section 100 allows filing of second appeals in the High Court if the High Court is satisfied that the case involves a substantial question of law, but not on any other ground. Substantial question of law is very, very important for your second appeal. And section 100 provides filing the second appeals in the High Court, and it mentions as follows. Save as otherwise expressly provide, did not body of this code of by any other law for the time being enforce, an appeal shall lie to the High Court for very decree passed in appeal by any court subordinate to the High Court, if the High Court is satisfied that the case involves a substantial question of law. For better understanding, I would like to explain this for one more time. Save as otherwise expressly provide, didn't the body of this code of by any other law for the time being in force, an appeal shall lie to the High Court from every decree, very decree passed in appeal by any court subordinate to the High Court, if the High Court is satisfied that the case involves a substantial question of law. An appeal may lie under this section from an appellate decree passed ex parte as well. In an appeal under this section, the memorandum of appeal shall precisely state substantial question of law involved in the appeal. What is the nature and scope involved in this second appeal? The sections declares that an appeal shall lie to the High Court from every decree passed in appeal by any court subordinate to the High Court, if the High Court is satisfied that the case involves a substantial question of law. So, such appeal lies also against an appellate decree passed ex parte as well. After the amendment in section 100, the consequences changed. What are those? The High Court must be satisfied that the case involves a substantial question of law, and the memorandum of appeal must precisely state such question or questions as well. An appeal should be heard only on that question or questions. So, what is the object of this one? The scope of the second appeals is very wide. It has been rightly observed in dealing with the second appeals, the courts has devised and successfully adopted several concepts such as a mixed question of fact and law, a legal interference to be drawn for the facts proved, and even the point that the case has not been properly approached by the courts below or the below courts. So, the Shah Committee, which dealt with the areas of cases in High Courts, observed it is necessary to provide for a stricter and better scrutiny of second appeals, and they should be made subject to special leave instead of giving an absolute right of appeal, limiting it to a question of law. So, this is very important recommendation by the Shah Committee. What did they say? it is necessary to provide for a stricter and better scrutiny of second appeals, and they should be made subject to special leave instead of giving an absolute right of appeal, limiting it to a question of law alone. What are the differences between second appeal and first appeal? What I have told you, explained you earlier, the above point describes the differences between second appeal and the first appeal. So, second appeal and the revision, what is this? Though a second appeal as well as a revision both lie in the High Court, there is a difference between the two. What is the difference? A second appeal lies to the High Court on the ground of substantial question of law, while a revision lies on a jurisdictional error, which is very limited. Revisional powers of the High Court can be invoked only in those cases wherein no appeal lies. Second appeal can be filed against a decree passed by a first appellate court. And substantial question of law, meaning it's not defined and universal application can be formulated as to when it can be said that a substantial question of law has arisen. Existence of substantial question of law is a sine qua non for exercise of jurisdiction under section 100 of the Code of Civil Procedure 1908. So what is the nature and scope of in this context? A High Court can entertain a second appeal provided that it is satisfied that the case involves a substantial question of law. The terms involves implies a considerable element of necessity. So what is the test point in this? Though the expression substantial question of law has not been defined in the court, the Supreme Court observed the proper test for determining whether a question of law raised in the case is substantial would, in our opinion, whether it is of general public importance or whether it directly and substantially affects the rights of the parties, and if so, whether it is either an open question in the sense that it is not finally settled by this court or by the previous counsel or by the federal court, or is not free from difficulty or calls for discussion of alternative views. This is the opinion expressed by the Supreme Court of India in the second appeals to define the question of law. So, basing on this and the interpretations, the questions of law can be framed for the second appeals subsequently. So, substantial question of law and question of law of general importance, what is this? For the purpose of invoking the jurisdiction of the High Court under section 100 of the Code, the substantial question of law need not be general importance. The Law Commission in its 54th report made it clear by observing that it should be noted that we are not limiting the scope of second appeal to questions of a law of general importance. If the law has been clearly laid down by the High Court and the decision of the subordinate court is in the clear violation of the law as pronounced by the High Court, the power of the High Court to correct it should be left intact. Formulation of questions. There should be some basis for the formulation of questions. Formulation of what questions? Formulation of a substantial question law is the sine qua non and condition precedent for the exercise of power by the High Court. So, in this context, what is the duty of the appellant? The code requires the appellant to previously state in the memorandum of appeal the substantial question of law involved in the appeal, which he proposes to urge before the High Court. And what is the duty of the court? If the High Court is satisfied that a substantial question of law is involved in the case, it should formulate such a question. Hearing of appeal. The code states expressly that the appeal shall be heard on the question formulated by the High Court. It thus interdicts the appellate from urging any other ground in appeal without the leave of the court. So, in this context, how the power of the High Court is saved? Proviso to subsection 5 of the section 100, however, preserves power of the High Court taking a second appeal for the final hearing to hear and decide the appeal upon any substantial question of law not framed or formulated at a time of admission of the appeal. This is the power of the High Court. So, substantial question of law involved can be explained in few examples. Whether or not in a particular matter a substantial question of law is involved depends upon the facts and circumstances of each case. Moreover, the expression involves implies a considerable degree of necessity. Substantial question of law where it is not involved. So what is the example for this? The following question can be explained where not held the substantial question of laws. Concurrent findings of fact recorded by the courts of or below courts. Finding of fact recorded by the first appellate court where two views are possible and where new case is sought to be made out in second appeal, where the High Court feels that the reasoning of the first appellate court is not proper. All these points can be considered where second appeal should not be considered. So, considering all the above definitions and explanations, you can clearly see that second appeal is not completely dismissed, but it is purely based on the question of law, and there are some certain guidelines as to how the question of law has to be framed in the appeal by the appellant. No second appeal in certain cases. What are those cases? Section 101 and 102. So, no second appeal is maintainable except on the grounds specified in the Code of Civil Procedure 1908, which was discussed earlier. So, no letters patent appeal, section 100A. Section 100A, as inserted by the Amendment Act 1976, enacts that no further appeal shall lie against a decision of the single judge in a second appeal. What is the next alternative we have? We can go to the Supreme Court. So, what is the limitation for second appeal? The second appeal lies to a High Court within a period of 90 days from the date of the decree appealed against. So, once that you get a first appeal, within 90 days you have to go for a second appeal in the High Court. Second appeal is not permitted, then you can go for a Supreme Court as well for an appeal. Form of appeal. Since the second appeal is maintainable only when it involves a substantial question of law, a memorandum of second appeal must precisely state such questions which are clearly explained. So, power of High Court to decide issue of fact, which is section 103. Though no second appeal lies on the question of fact, only on question of law, when such appeal is already before the High Court and the evidence on record is sufficient, it may decide any issue of fact necessary for disposal of the appeal if such issue has not been determined either by the trial court or by the appellate court or by both, or has been wrongly determined by such court or courts by reason of its or their decision on the substantial question of law. So, even the second appeal is not purely on the basis of a question of law. Question of fact also can be considered, but it is in a very rare cases where three conditions have to be fulfilled as explained earlier. So, what is the procedure at hearing? The provisions relating to first appeals shall apply to second also. So, what is it? Pending appeals. The right of appeal is a substantive right and is not merely a matter of procedure. Moreover, institution of a suit carrier with it a right of appeal which is vested right, and such right is governed by the law prevailing at the date of filing of suit or proceeding, and it cannot be abrogated or curtailed by a subsequent legislation. So, what are the general principles? From the aforesaid discussion, what I have explained right now, the following general principles can be decided regarding second appeals. What is the first one? The second appeal lies in the High Court. Such an appeal is maintainable only on substantial question of law alone, but in some cases question of fact also can be expressed by fulfilling the three conditions. An appeal lies also against an ex parte decree as well. No second appeal lies except on grounds mentioned in section 100, that is except on substantial questions of law. Thus, no appeal can be filed on a question of fact, question of law, or mixed question of fact and law. So, appeals from orders, once an order is given which is not a judgment, appeal can also be filed in the High Court. In general, section 104 to 108 and orders 43 deal with appeals from orders. They state that certain orders are appealable. What is the meaning of order? Meaning, the formal expression of any decision of a civil court which is not a decree. Thus, an adjudication of a court which does not fall within decree is an order. So, order and decree. In spite of some similarities, an order differs from a decree. So, what is the nature and scope? The code has made certain orders appealable. Appeals can be filed only against those orders which are made appealable. No appeal lies from other orders. So, appealable orders, section 104, order 43. An appeal shall lie only from few orders, appeal can be made. An order awarding compensatory costs in respect of false or vexatious claims or defense Section 35A, an order refusing leave to institute a suit against public nuisance. Section 91. And like this we have many more points, but all these points cannot be discussed in this class. So I strongly recommend you to please refer to famous Civil Procedure Code 1908 written by very famous authors. In that you will find exceptional cases where second appeals can be made and also cannot be made as well. So what are the other orders? Other orders are Section 105 Rule 1A. Section 105 enacts that every order, whether appealable or not, except an order of remand, can be attached in an appeal from the final decree on the ground. What are those grounds? That there is an error, defect or irregularity in the order, and that such error, defect or irregularity affects the decision of the case as well. So this is a clerical or judicial office mistake which can be appealed. And does res judicata apply? The doctrine of res judicata applies to two stages of the same litigation also. Hence, if any interlocutory order has not been challenged, the same would operate as res judicata at all subsequent states of the suit, and no party can be allowed to set the clock back during the pendency of the proceedings. This is well explained in my earlier classes on res judicata. So if you have any doubts on this concept of res judicata, please refer to my earlier classes. So do we have limitation? Yes, and limitation from an order can be filed in a high court within 90 days and in another court within 30 days of the date of the order. What is a forum of appeal? Section 106. Appeals from orders in cases in which they are appealable shall lie to the court to which an appeal would lie from the decree in the suit in which the order is made. So procedure at hearing, what will happen after the second appeal has been instituted? The provisions relating to first appeals shall apply to appeals from other orders also. So letters patent appeal, yes. Subsection 2 of section 104 states that no appeal shall lie from any order made in appeal. The question may arise whether a letters patent appeal would lie against an order passed by a single judge of the High Court. So, after this, what happens? What is the option you are left with? Appeal to the Supreme Court. The bar to further appeal under section 104 subsection 2 does not apply to appeals to the Supreme Court. So, once the second appeal is over, you can still apply to the Supreme Court. So, appeals by indigent person. Indigent person means a person who cannot afford to pay the court fees at any stage. So in general, as discussed earlier, Order 33 deals with suits by indigent persons. Order 44 deal with appeals by indigent persons also. So the provision of the Code 44 are subject in all matters to the provision of Order 33 insofar as they are applicable. So who may appeal? According to Rule 1, any person entitled to prefer an appeal who is unable to pay court fee required for the memorandum of appeal may present an application accompanied by memorandum of appeal and may be allowed to appeal as an indigent person. Before the Amendment Act 1976, certain restrictions were imposed on the right of an indigent person to prefer an appeal under Subrule 2 of Rule 1. It provided that the court shall reject the application to appeal in form paupers unless it is shown that the decree is contrary to law or to some usage having the force of law or is otherwise erroneous or unjust. So, before this an inquiry can be filed. Under Rule 3 provides that where an appellant was allowed to sue as an indigent person in the trial court, no fresh inquiry is necessary if the applicant files an affidavit to the effect that he has not ceased to be an indigent person since the date of the decree appealed from. So, power and duty of court. At the stage of hearing of an application, the question to be considered by the court is whether the applicant is an indigent person. If he is, the applicant will be allowed and the memorandum of appeal will be registered. If he is not, the application will be rejected. So, payment of court fees in appeals, which is Rule 2. The rejection of an application for leave to appeal as an indigent person does not ipso facto result in the rejection of the memorandum of appeal filed along with the application. So, what is the limitation for this? The period of limitation for the presenting an application for leave to appeal as an indigent person to the High Court is 60 days and to other courts is 30 days. So letters patent appeal. There is a difference of opinion as to whether a letters patent appeal lies against an order granting or refusing to grant leave to appeal as an indigent person. So the majority opinion, however, is that an appeal is maintainable against such orders. And in this context, further chance of appealing is appeals to the Supreme Court. What is that? In general, appeals to the Supreme Court are governed by the provision of Articles 132, 133, 134A of the Constitution of India with regard to civil matters. Subject to provisions of the Constitution, an appeal shall lie to the Supreme Court from any judgment, decree, final order in a civil proceeding of a High Court if the High Court certifies that the case involved a substantial question of law of general importance and in the opinion of the High Court, the said question needs to be decided by the Supreme Court. So sections 109 and 112 read with order 45 deals with appeals to the Supreme Court. So conditions, what are those conditions? Section 109 order 45 rule 3. An appeal should lie to the Supreme Court under section 109 of the code only if the said conditions are fulfilled. A judgment, decree or final order must have been passed by the High Court. A substantial question of law of general importance must have been involved in the case and in the opinion of the High Court, the said question needs to be decided by the Supreme Court. So what is a judgment, decree or final order? An appeal lies to the Supreme Court only against judgment, decree or final order of the High Court. So a judgment, decree, final order against which an appeal can be preferred to the Supreme Court must be one which purpose to put an end to the litigation between the parties. No certificate can be granted in respect of an interlocutory order. The test whether the order is final or not will not depend on whether the controversy is finally over, but whether the controversy raised before the High Court is finally over or not. This is the greatest difference while going for the Supreme Court, which is very well explained by many great authors. So, substantial question of law of general importance. An appeal would lie to the Supreme Court if the High Court certifies that the case involves a substantial question of law of general importance, need to be decided by Supreme Court. It is not sufficient that the case involves a substantial question of law of general importance, but in addition to it, the High Court must be of the opinion that such question needs to be decided by the Supreme Court. The word needs suggests that there has to be a necessity for a decision by the Supreme Court on the question, and such a necessity can be said to exist when, for instance, two views are possible regarding the questions and the High Court takes one view of the said views. So what is the procedure at hearing in the Supreme Court? Application for leave and certificate of fitness. Whoever desires to appeal to the Supreme Court shall apply by a petition to the court whose decree is sought to be appealed from. Ordinarily, such a petition should be decided within 60 days from the date of filing of the petition. Every petition should state the grounds of appeal and pray for the issues of a certificate. So, what kind of certificate? That the case involves a substantial question of law of general importance and that in the opinion of the court, the said questions needs to be decided by the Supreme Court only. So, effect of amendment in Constitution. These provisions, however, must be read in the light of and subject to Articles 134A of the Constitution. By the Constitution, Article 134A has been inserted with effect from 1st August 1979. It states that every High Court passing or making a judgment, decree or final order or sentence referred to in Article 132 Subarticle 1 or 133 Subarticle 1 or 134 Subarticle 1 may, if it deems so to do, either suo motu or shall, if an oral application is made, by or behalf of the party aggrieved, immediately after passing the order or making of such judgment, decree, final order or sentence, determine whether a certificate may be given or not. Security and deposit for the making an appeal in the Supreme Court. Rules 7, 9 and 12 of the sections apply. When the certificate is granted, the applicant should furnish security for the cost of the respondent and also deposit the expenses for translating printing, indexing, etc. within the stipulated period, the court may revoke acceptance of security. The court has also the power to refund the balance of the deposit after necessary deductions for expenses. So after this, what happens? Admission of appeal, which is Rule 8. Where the directions regarding furnishing of security and making of a deposit are carried out, the court shall declare the appeal admitted, give notice thereof to the respondent, and transmit the record to the Supreme Court. If the security furnished or the cost deposited appears to be inadequate, the court may order for the security to be furnished or costs to be deposited. So powers of court pending appeal. The pendency of an appeal to the Supreme Court does not affect the right of the decree holder to execute a decree unless the court otherwise directs. Execution of orders of Supreme Court, Rules 15 and 16. An appeal will then be heard by the Supreme Court and an order will be made. Whoever desires to execute a decree or an order of the Supreme Court shall apply by a petition accompanied by a copy of the decree or order sought to be executed to the court from which the appeal was preferred to Supreme Court. So appeals under Constitution. Over and above Articles 132, 133 and 134A, Article 136 of the Constitution confers very wide and plenary powers on the Supreme Court to grant special leave to appeal from any judgment, decree, determination, sentence or order passed by any court or tribunal. Section 112 of the Code says the power conferred on the Supreme Court by the Constitution and declared that nothing in the Code of Civil Procedure would affect their powers. So, these are all the parts of the important aspects related to the second appeals in the High Court and as well as appeal in the Supreme Court under different sections. I compiled this information from very profound books and I hope you like this explanation. And as I'm telling it right from the beginning itself, that I'm doing all these classes as a charity to an organization by name ABC Trust. So if you are happy with this class, may I request you please donate a small donation of 59 rupees to the charitable organization ABC Trust through the UPI. The UPI number is 994939 8998, and at the end of this class I will be showing you an QR code. You can scan the QR code from the UPI and you can the donations as well. In addition, very important thing is your subscriptions are very important for me as an encouragement for doing more classes in the future. So I hope you will oblige my requests and thank you very much. Namaste.